is saying and the implication of what they are saying with regard to the question, each of the questions of capacity. Okay?
Please excuse me, sir.
Yes.
I have a quick question. Under this antinuptial domicile, does it, I
Yes.
don't know if I'm ahead of please, does it mean that the parties would be married in the domicile of the husband, validly married, but in the domicile of the wife, they have an invalid marriage?
Well, the antinuptial domicile will say that there was no marriage at all. Because what the antinuptial domicile will require is that each party, each spouse will meet not only the requirement of his or her own domiciliary, but the requirement of the other spouse domiciliary too. So when you are applying antinuptial domicile, if any of those 4 questions, the answer is negative, then there was no marriage. Unlike when you are applying matrimonial home domicile, that you don't even ask any question of the wife's own domiciliary law. You just use the answer of the husband's domiciliary law because you have assumed that it is the husband's environment that is interested, being the host of the relationship. It is the husband's environment that you should look at. So Churchill argues that unless the marriage was based on an understanding that a new domicile of choice will be acquired, the domicile of the husband should govern as far as the question of capacity is concerned. Okay?
Okay, sir.
So if you can lay your hand on any basic English text, I've told you that it is English law we receive in the area, so there's nothing wrong in reading English text for this thing. You can enjoy the topic called derivative theories. They will call it derivative theories, and they will be discussing what Daisy said and what Cheshire said. Okay? For example, Cheshire says, giving his own reasons for matrimonial domicile, he says, whether the intermarriage of 2 persons should be prohibited for social, religious, hygienic, or other like reason is a question that affects the community in which the parties live together as man and wife. That is the basis of Cheshire's own conclusion. Okay? But what is Dicey's own theory? What is the basis of his own theory? Dicey says the capacity to marry is and ought to be governed by the law of each party's antinuptial domicile. So his theory is otherwise called the dual domicile theory. Okay? And his own view is based on the idea that the community to which each party belongs is interested in his or her status, and that in these days of sex equality, no preference should be shown to the laws of one community rather than the laws of the other. Can you see the rationale of each theory? Can you see the rationale of each theory? As a patriarchal person, I will go for Cheshire's theory any day. Eh? Shouldn't I? The boys.
So debatable, sir.
No, sir.
Are you not going to create a serious problem?
No.
When you begin to go back into
Sir,
history, and say that because even the religions, especially Christianity, teaches that they become one. That one that they become upon marriage, is it a he or a she? I ask.
Them.
A them. Did somebody say a them? Anyway, those are the rival theories. And the biggest problem usually is in trying to justify each theory by the case law. I want to tell you not to dare it because you get confused. Just let us dabble into what are the grams that fall under capacity. Okay? Reserve the issue of examining the English cases and seeing which of the rival theory is supported by them. Reserve it till your masters. Already it's confusing enough, so I don't want to confuse you the more. Let's just look at what are the issues under Anglo-Nigerian private international law that is often regarded as issues of capacity. Okay? What are the issues? Number one, age. Marriage age is an issue of capacity. Okay? Two, marriage age is an issue of capacity. You want to read a case where age of marriage became an issue and how the English court resolved it. Read the case of Pugh and Pugh, P-U-G-H and P-U-G-H. Now, what happened in Pugh and Pugh?
So we can't hear you again now.
Pugh and Pugh was a case. You see, the biggest problem with analyzing these cases is that you have different factors that differentiate cases one from another. For example, if a marriage was celebrated in England, okay, and one of the couple is also domiciled in England, that may be different from a situation where the marriage was celebrated abroad and one of the couple is domiciled in England. Okay? You know, in law, when we say cases are at all false, you can distinguish between the two. And you can begin to say that, well, this one was different because England was also the place where it was celebrated. But in Pugh and Pugh, it was heard that if a marriage celebrated in England, one of the parties was less than marriage age, that is age of 16, okay? Regardless of the domicile of the parties, the marriage will be a nullity. The marriage will be a nullity. Okay? Now, what do we get from this? The facts. Let's look at the facts. A marriage was celebrated in Austria between a British officer domiciled in England was stationed in Austria, and a girl of 15 domiciled in Hungary. 4 years later, the parties came to England in accordance with their antenuptial intention, but parted almost at once. Now you know that that marriage will be valid. The marriage was valid by Australian and Hungarian law, but the court held that it was void. It therefore appears that no marriage is valid if either party is under 16. If either party, not necessarily the party under age, is domiciled in England. Okay? That is the way Dicey rationalize it. Listen, let's go to the fact again and see how Dicey said he supports his own theory. Okay? The marriage was celebrated in Austria. But this is not a question of form. So the celebration in Austria is not relevant. But it was celebrated between a British officer domiciled in England. Okay, the status of the man as British officer is not relevant. It was celebrated between an English domiciliary and a Hungarian domiciliary. Okay? By Hungarian law, the marriage was valid. The meaning is that 15 is the age of marriage in Hungary, or was the age of marriage in Hungary. By Australian law, the marriage was also valid, even though we said local of celebration is irrelevant. They have just mentioned it because that's where it was celebrated. But by English law, which is the domiciliary law of one of the parties, a girl age 15 was not qualified for marriage. The marriage age was 16. Okay? So you can see, according to Dicey, that it was the girl's failure to meet the domiciliary law of the boy that rendered the marriage void. So Dicey will use this case to show that, yes, I am correct to say that it is antenuptial domicile. But Morris will also use it. Morris will also use it. What is the other one's name? Cheshire will also use it. Because if we say, well, England is the matrimonial home because it is the domicile of the man. So, as far as we are concerned, neither of them is able to rely on Puck and Puck, or both of them are able to rely on Puck and Puck. Okay? Since it was the man who was domiciled in England, if the fact were to be reversed and the woman will be the one domiciled in England and the man domiciled in Hungary, and the English court will still go ahead to hold that the marriage was a nullity, then it will support Dicey's position. But if the man was the one domiciled in England, both positions would be able to say, yes, I told you. And then they will leave you confused because it supports both propositions. But at any rate, what do we want to know? Puck and Puck illustrates that lack of age is a capacity issue. There is a capacity issue that can nullify, that can be used to nullify a marriage with a foreign element. Okay? So that is lack of age. Okay? The second issue is prohibited limit of consanguinity and affinity. prohibited limit of consanguinity and affinity. Those of you who did family law, you are aware of that. You can't marry you cannot marry your brother's wife, okay, or your sister's husband, okay? Consanguinity and affinity, they are prohibited limits. And every legal system will have our own different approach to the matter, okay? In some legal system, first cousins can marry. In others, they are too close. They will be within prohibited limits of affinity. In some legal system, nothing is wrong with marrying the sister of your wife upon your wife's death. But in other legal system, that will be within the prohibited limit of consanguinity. Okay? So, where people from different domicile marry, and the domiciliary law of one spouse permits the marriage, and that of the other spouse does not permit it, can the marriage be valid? Let's look at the cases that have been decided on that. The first case is the case of Brook and Brook. Brook and Brook, the decision is very difficult to rely upon because the judge couched the judgment as if they are using Lex Loci celebrationis. But let's look at the facts. Let's look at the facts. A man and his deceased wife's sister, that's prohibited limit of consanguinity. Sorry, is it affinity or consanguinity? Consanguinity is blood relations. Affinity, which one? Which one is consanguinity and which one is... Hello?
Marriage. Is marriage.
Which one is consanguinity? Which one is affinity? Affinity, I think, is
Marriage.
in-law relations. Consanguinity is brothers' relation, isn't it? Am I correct?
Yes, sir.
Consanguinity is blood.
Okay, so this one is prohibited limit of affinity. Okay, so on prohibited limit of affinity, look at the case of Brook and Brook. A man and his deceased wife's sister, both British subject domicile in England, went through a ceremony of marriage during a temporary visit to Denmark, by whose law the marriage was valid. Okay? What is the relationship of Denmark to the marriage? It is the local celebrationis. It is the local celebrationis. Can it validate the marriage when the question is prohibited limit of affinity? Answer no.
No.
At least not by our own conflict of law rules. Okay? What will validate the marriage? Domicile. So this case shows us that both were British subjects domicile in England. Okay? So what they simply did was to leave England, go to Denmark. Shebi England say no go agree. Let's go to Denmark, Joe. So they went to Denmark. And by then, by the law of Denmark, that type of marriage was allowed. So the husband, the wife, and one of the infant children of the marriage died within a few days of each other in epidemic of cholera. Okay? The question was, what is the status of that child or the remaining children? One of the infant children, together with the husband and the wife, died in an epidemic of cholera. At least one survived. The ability of that one to inherit will depend on legitimacy. You see, I normally tell people that when you are looking at the subject falling into the area of personal status, they are together. Whenever you discuss inheritance, the question of legitimacy will come in. Whenever you discuss legitimacy, the question of validity of marriage will come in. Marriage is the root of all of the other issues. That is why each time you talk about legitimacy, succession, capacity to make will, there will always be an incidental question. And that incidental question will be validity of marriage. In Fonseca and Passman, marriage was an incidental question because the issue was, just like this one, the right of the children to inherit. And you saw how our court, with due respect to them, betrayed the lack of knowledge of the subject area by simply denying those children and saying that Oyinbo man had no capacity to marry under customary law. That's their own answer. I think an Oyinbo man must have presided over those courts. I'm not sure. Okay? But look at this one now. So what happened in this case was the question of legitimacy of the children, so as for them to qualify to inherit. If there was no marriage, they will not be legitimate. But if there was a marriage, they will be legitimate. The court held that the marriage was void, that the children were illegitimate, and that therefore the dead child's 1/5 share of the family property passed to the crown as bona vacantia and not to his natural brothers and sisters. Okay? So it was not, this was not a case to nullify the marriage. The marriage was an incidental question in determining rights to inherit the share of the deceased child. Okay? If the deceased child had been considered legitimate, the other children would have inherited his share. But if all of the children were considered illegitimate, then the share of that deceased child will go to the crown as bona vacantia. Okay? So the final answer was the marriage was not valid. Therefore, the deceased child was illegitimate, and therefore, it is the crown who inherits him and not his brothers. What is the lesson for us in a class of marriage? The lesson for us is that in this case, the lex loci celebrationis was not considered relevant. Okay? What was considered was the lex domicili, which proves that domicile governs capacity. This one did not throw up antinuptial because both of them were domicile in England. So whether you are using matrimonial home domicile or you are using antinuptial domicile, Brook and Brook will still be decided the same way because both were domicile in England. Okay. Then there is the case of Sotomayor and the Barrows. Sotomayor and the Barrows number 1. Sotomayor and the Barrows number 1. That one is prohibited limit of consanguinity. Okay. Two first cousins supposedly domiciled in Portugal, married in England. The marriage was valid by English law. So English law permits first cousins to marry. Okay? But invalid by the law of Portugal, under which first cousins could not marry without papal dispensation. Okay? The parties were very young. The boy was age 16 and the girl 40 and a half. The marriage was one of convenience only, arranged for them by their parents, and though they lived together in the same house in England for 6 years, the marriage was never consummated. The girl then petitioned for a decree of nullity on the ground of consanguinity. The suit was undefended, but the Queen's proctor intervened and alleged, inter alia, that the parties were domiciled in England and not in Portugal, that they intended at the time of the marriage to live together in England and did so live for 6 years, and that the validity of the marriage was determined by English domestic law. The somewhat inconvenient course was taken of ordering that the question of law should be argued before questions of fact, on the assumption then that the parties were both domiciled in Portugal at the time of the marriage. The Court of Appeal held that the marriage was void because, as in other contracts, so in that of marriage, personal capacity must depend on the law of domicile. Personal capacity must depend on the law of domicile. Okay? So, this at least supports our inquiry is 2 in number now. Number 1, whether consanguinity is a lex loci celebrationis issue or a lex domicili issue. So Sotomayor and the Barrows confirmed that consanguinity, just like Brook and Brook, is a lex domicili issue. But at the end of the day, it doesn't support either rival theories because both were domiciled in England. Sorry, both were domiciled in Portugal. And Portuguese law itself did not permit the marriage. Portuguese law says they will not be married when they are within that limit of consanguinity, unless there is a papal dispensation, and there was no papal dispensation. So the English court held that it is Portuguese law that will govern. Portuguese law being the law of the place of domicile. And by Portuguese law, they were not validly married. The marriage would have been valid if it was governed by English law. Okay? So the intervener was trying to argue that the relevant domicile is not that of Portugal, but that of England, which was their intended matrimonial home domicile. Okay? But I think the court rejected that, okay, and said that the relevant domicile, the applicable domicile is Portugal. So you can find Dicey saying that this supports him. Why? Because the court seemed to have rejected the argument of intended matrimonial home domicile, which the English authority argued that was England. So Dicey can say this supports him. But don't bother yourself about this. They are very difficult theories. Okay? Just use Sotomayor and the Barrows to show that the question of prohibited limit of consanguinity is not a form issue. It is a capacity issue, and the answer is in the lex domicili. Okay? If your examiner wants to trouble you, he then tells you that there are domicile in different countries. But if he doesn't want to trouble you, he keeps it within the fact of Sotomayor and the Barrows. Okay? You can see from Brook and Brook that the English people are not partial. In Brook and Brook, the couple were domiciled in England because English law did not permit the marriage between them. The court nullified the marriage, or the court did not say that there was a marriage. In Sotomayor and the Barrows, the couple were is it Portuguese? They were Portuguese, and by Portuguese law, the couple were Portuguese domiciliary, not national. They were Portuguese domiciliary, and by Portuguese law, their marriage was well within prohibited limit of consanguinity. The only thing that will save it was papal dispensation, which they did not get. The English court again, applying the lex domicili, held that marriage will be a nullity everywhere because it is a nullity by the law of the place of domicile. Is it clear? Is it clear?
Yes, sir.
So you go and read two other cases, which I normally give. The case of the Will of Swan causes domicile in British. Okay?
Sir, we didn't hear you, sir.
I said two first cousins, domicile in British Columbia, wished to marry. The girl was age 18. She was unable to obtain the consent of her parents as required by the law of British Columbia. So the parties were married in the state of Washington, where such consent was not required. But unknown to them, first cousins were incapable of marriage by law of Washington, though they were capable by the law of British Columbia. So let's look at this. Let's seriously look at this. Before I tell you what the court decided, I want to task you to tell me what should be the answer. Okay?
Please, you did not get the name of.
Yes. I want to give it to you now.
So-
Read and read. R-E-E-D and R-E-E-D. Okay? They were first cousins. Both of them were domiciled in British Columbia and they wished to marry. The girl was age 18. Okay? And by British Columbian law, at that age, she will need to obtain parental consent. She was of age to marry, no doubt, but she would need to obtain parental consent. And her parents did not give their consent. So what did they do? They relocated to Washington. They relocated to Washington because Washington did not require consent, parental consent. But unknown to them, first cousins were within the prohibited limit of consanguinity, even in Washington. They won't be within the prohibited limit of consanguinity in British Columbia, but they will be within the prohibited limit of consanguinity in Washington. And the marriage was solemnized in Washington. Okay? So, how do you answer that question? This one is the real question that tests your understanding of everything. So, I want to hear you. Maybe I give you 5 minutes to think deeply. Then you give me the answer. What should the answer be before I tell you what the court decided?
I don't think the law of Washington should even apply because this is a question, this is not a question of form. So it's not like Lex Loci celebrationis cannot apply. I think
that is it. That is the final answer. That is the final answer. The question of prohibited limit of consanguinity is capacity. Capacity is governed by domicile. Domicile is British Columbia. British Columbian law permits the marriage. The marriage is valid. On the other hand, the question of parental consent is form. Form is governed by Lex Loci celebrationis. The marriage was celebrated in Washington where the law did not require parental consent. So you can use Lex Loci celebrationis to invalidate the marriage, and you can use Lex domicilii, which applies to capacity to invalidate the marriage. On that note, the court held that the marriage was valid. The court held that the marriage was valid. Okay? You see why they say that this subject is, is difficult. You can't just give an answer. You have to pause and look at the facts and rationalize the facts before you arrive at a correct conclusion. So what are the other issues? The question of previous marriage. The question of previous marriage. Why is the question of previous marriage a capacity issue? It is a capacity issue because the domicile will have to recognize that there was no previous marriage before the new one you want to go into will be valid. Okay? So, two countries might have different approach to your previous marriage. Okay? One might say the marriage was a nullity. The implication of that one country saying the marriage was a nullity is that you would be able, by their own understanding, to enter into a new one, which will be valid. The other might say that your previous marriage subsists. It's not only valid, it has not been nullified, it has not been dissolved. Such a country whose own perception is that your marriage is still valid will, of course, bar you from entering into another one, especially if we are talking about monogamous marriage. So, previous marriage whether or not one of the spouses had a previous marriage can then be a question of capacity. So you can then have a situation where the country of the female spouse, for example, recognize her previous marriage to someone else, while the country of the male spouse treat her previous marriage to someone else as a nullity. If the two of them marry, how do we determine the validity of that marriage? So the first thing is to understand that it's a question of capacity. Okay? It's a question of capacity. And that it is governed by domicile. Okay? And that it is governed by domicile. So, but let's see what happened in Padolochia and Padolochia. Padolochia and Padolochia. I normally use Padolochia and Padolochia and
Sorry,
show and
sir.
prove. Yes?
Good afternoon, sir. So we have another class now.
Oh, okay. We are really enjoying ourselves on this marriage thing. No? When is your exam coming?
Sir, March.
27th of March.
27th of March.
Yes, sir.
Having starting on the 27th, but exam is starting 17th.
17th of March.
Yes,
Yeah.
that's when exam is starting.
But
So we can
conflict, you
enjoy.
know.
We can enjoy ourselves. We have only one topic left for first semester, and that is thought. Let's enjoy ourselves. Okay. So
Sir,
I see you next week.
Sir, what about our assignments for CA, sir?
Say,
So, he was referring to our assignments for CA because like we've been grouped, but we've not been given any further instructions.
I'm not sure he's still on the call.
Sir, you are currently muted.
I think he has left his phone. We'll ask in the next class.
Hello, sir. We can't hear you. Maybe Aderemi can help us confirm from him after.
the car.